Good morning. I'm Gary DeWaal, and this is Bridging the Week for July 11th to 15th, and today is July 18th, 2016. Last week, the first individual prosecuted and convicted under the provision of the Dodd-Frank Wall Street Reform and Consumer Protection Act that prohibits spoofing was sentenced to 3 years in prison. Meanwhile, committee members and witnesses appearing before the House Committee on Agriculture's hearing on the Commodity Futures Trading Commission's proposed regulation automated trading attacked the proposal's requirements related to source code and registration, while commentators also criticized in writing many aspects of the CFTC's recently proposed amendments regarding non-enumerated hedge exemptions to its November 2013 position limits rule proposal. This was despite generally being supportive of the agency's willingness to permit exchanges to grant such exemptions in the first instance. I have a pile of work I have to urgently address, so I can get to my day job. Let's get started. Last week, Michael Coscia, the first person prosecuted and convicted under a law prohibiting spoofing that was enacted after the 2007-2008 financial crisis, was sentenced to 3 years imprisonment for allegedly illicit futures trading he engaged in during 3 months in 2011. In July 2013, Mr. Coscia had settled civil actions related to the same conduct with the Commodity Futures Trading Commission, the Financial Conduct Authority, and the CME Group by payment of aggregate fines of $3.1 million, disgorgement of profits, and a 1-year trading suspension. Frankly, it seems somewhat draconian that Mr. Coscia was sentenced for violating a new law for which he already paid substantial civil sanctions, which on its face appears to permit at least some legitimate trading practices, and which may not have given him adequate notice of prohibited conduct. Unfortunately for Mr. Coscia, the judge hearing his case did not have a problem with the clarity of the relevant statute and, in any case, believed that Mr. Coscia should have known his specific trading was prohibited. It will likely be up to an appeals court to again consider the constitutional validity of the relevant law. The Commodity Futures Trading Commission filed and settled charges against 2 unrelated Singapore-based commodities trading firms for not filing with it reports of their physical positions. In one action naming Golden Agri International Pte. Ltd., the CFTC claimed that from April 2014 through October 2015, the firm failed to file with it 5 Form 204 reports identifying the physical positions associated with its hedge positions in soybean oil futures. Golden Agri agreed to pay a fine of $150,000 to resolve this matter. In a separate action, the CFTC claimed that Agri-Corp International Pte. Ltd., a cotton dealer, failed to file with it 22 required Form 304s at various times in 2012 and from October 7, 2014 to February 13, 2015. Agri-Corp also agreed to pay a fine of $150,000 to settle this action. A disproportionate amount of foreign firms seem to be caught by the CFTC Enforcement Division's web in connection with breaches of these esoteric Form 204s and 304s. Citigroup Global Markets Inc. agreed to pay a $7 million fine to the Securities and Exchange Commission to resolve charges that, from 1999 through 2014, it submitted over 2,300 erroneous blue sheets with it and 753 erroneous blue sheets with the Financial Industry Regulatory Authority. In case you forgot, blue sheets refer to trade data submitted by certain regulated entities, including broker-dealers, to the SEC and FINRA in an automated form in response to requests by the regulatory bodies in connection with their investigations, typically of equity market activity. According to the SEC, Citigroup errors occurred as a result of a coding error in the firm's electronic blue sheet computer system that was not detected until 2014. Moreover, the SEC said it was advised of Citigroup's blue sheet issue, quote, over 9 months after the issue was identified, end of quote. That being said, the SEC noted Citigroup's remedial acts and cooperation in accepting its offer of settlement. Just 2 weeks ago, Deutsche Bank Securities Inc. agreed to pay a fine of $6 million to resolve charges brought by the Financial Industry Regulatory Authority that had filed, quote-unquote, thousands of deficient blue sheets with it and the Securities Exchange Commission from 2008 through 2015. Accurate blue sheet reporting is clearly on both the SEC's and FINRA's radar. Members of the House Committee on Agriculture and all 4 witnesses that appeared before it last week during a public hearing on the Commodity Futures Trading Commission's proposed regulation on automated trading were generally critical of the Commission's initiative. In his opening remarks, Committee Chairman K. Michael Conway expressly warned that the Commission's proposal for it and the Department of Justice to have quote-unquote on-demand access to algorithmic trading source code, quote, is fraught with danger, end of quote. He also suggested that the Commission's proposal to require certain algorithmic traders who directly access exchanges to register with it as floor traders not only raises a quote-unquote legal question in light of the congressional purpose in initially creating that registration category, but also may, quote, unintentionally capture thousands of end users, end of quote. Mr. Conway suggested that, as an alternative to his current proposed rule, the CFTC consider leveraging, quote, already ongoing processes across the industry to impose and refine risk controls, end of quote. In his testimony, Richard Gorlick, CEO of RGM Advisors, LLC, likened the CFTC's claimed need to access source code in order to better detect potential market disruptions to disassembling and studying the parts of an automobile in order to better predict driving conditions in the future. Mr. Gorlick also argued that, quote, Reg AT tries to accomplish too much in a single regulation, making it unwieldy and impractical, end of quote. And finally, in comment letters filed with the Commodity Futures Trading Commission, futures industry participants generally supported the Commission's recent proposed changes to its November 2013 proposed position limit rules in order to permit exchanges to approve non-enumerated hedge exemptions, spread exemptions, and anticipatory hedge exemptions, as well as to delay exchange set position limits for swaps. However, industry participants were critical of the potential CFTC review of any exchange-granted exemption, the requirement that a designated contract market have 1 year experience in administering position limits in order to grant exemptions, the requirement that applications for non-enumerated or anticipatory hedges be accompanied by 3 years of cash market activity, and the interpretation of bona fide hedging to include only price risk as opposed to all risks that might affect cash markets, including time risk, location risk, quality risk, and credit risk, among others. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Until next week, have a great week, and ciao.